Good day. My name is Mbulelo Kabuko. I'm the Director, National Health Information System.
All right, so it's Dr. Pillay or Mr. Pillay?
Dr. Pillay.
Dr. Pillay. And Mr. Kabuko or Dr. Kabuko? Mr. Kabuko. All right. Thank you. How are we going to do this? Dr. Pillay, are you going to take the oath or the affirmation?
Yes, I have no problem doing so.
All right, thank you. Let's do that. Will you just say then after me, I and your name?
I, Anben Pillay,
Swear that the evidence that I shall give
swear that the evidence thou shalt give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and raise your right hand and say, so help me God.
so help me God.
Mr. Kabuko, are you also going to be speaking?
I will be supporting Dr. Anben Pillay.
All right, so maybe let me take your oath as well then. So will you say after me, I and your name?
I, Mbulelo Kabuko,
Swear that the evidence that I shall give
swear that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and if so, raise your right hand and say, so help me God.
so help me God.
Thank you. All right, Dr. Pillay, the floor is yours. We have not received a written submission from the department, but I presume you will take us through what you have to say.
Thank you, Chair. We received the invitation, or I received one yesterday, and so I didn't have an opportunity to put together any presentation at this stage. I understand there were two matters that you wanted to discuss with us. One relates to procedure codes, and the other relating to the National Health Reference Price List history.
All right, let's just clarify this. You say you received the invitation yesterday?
Yes, I myself, yes.
Yes, because the invitations were sent a couple of weeks ago. So it's unclear why you then received it yesterday.
Yes, I'm not talking on behalf of my department, I'm talking on behalf of myself. So I'm saying I received it yesterday, yes.
So it went to the department, but it didn't come to you?
Yes, that's what I'm saying.
All right. All right, thank you. All right, so what have you prepared?
So it wasn't clear to me exactly what you were looking for in terms of these two areas. I would be able to speak to you about the reference price list, and Mr. Sabuko would be able to talk to you about the ICD-10 codes, but we don't have a presentation as such, so we're hoping that you would have some questions for us, which we can then respond to.
Yes, no, we will do that. Look, I mean, I think that the fact that we sent an invitation a couple of weeks ago and that it seems to have been lost in the system, and for you to arrive today with no presentation and also with no clarity about what the Commission is looking for, in circumstances where we were announced more than 2 months ago, and in circumstances where everybody else who has come before the department has come with a written presentation and has come with a clear sense of what they would like to do with the Commission. That is something that will have to be taken up with the department. Do you know how the invitation got lost in the system?
No, I can't speculate on that.
All right, thank you. Perhaps then let's use the time meaningfully. You have things to say, then we will ask questions in due course. Thank you.
Maybe I can start by talking about the reference price list. So the reference price list had been established several years ago. In around 1994, there was a process for establishing a price list through the RAMS process. And that eventually led to a reference price list which the Council for Medical Schemes administered. The process basically involved a costing exercise of what it costs to deliver services, and a list was then put up for each type of service and what the price is linked to that. We in the department then came up with regulations to formalize this process, because the process had largely been ad hoc prior to that. So we defined the way costs should be calculated, who should calculate it, and how those costs should be presented. And we undertook an exercise to verify costs. We embarked on that exercise after finalizing regulations. And at the end of that exercise, we came up with prices for a range of services. The providers of healthcare were not very happy with the draft prices that were produced, and then decided to take the matter to court after initially participating with us in the process. And their arguments in the court was that the regulations were not appropriately established because the regulations were established in terms of the National Health Act and required concurrence with the National Health Council.
Is this the case that was brought by the Hospital Association of South Africa?
That's right. Yeah, it wasn't just the Hospital Association; it was everybody actually, including the doctor groups, etc., who joined the case. And so the regulations were struck down, and there was then no reference price list, which also affected the coding, which is the other area I think you're interested in, because the prices are obviously linked to procedures, which are then effectively summarized into a code. And so they kind of go hand in glove. In the absence of a reference price list, we then engage the industry to deal with this lacuna through some sort of a voluntary process where the industry would be willing to share information about costs, and we would be willing to then put up a reference price list. And if that went well, we would read draft regulations. There were many sectors of the industry that were not willing to cooperate with us in terms of that, and indicated the Competition Act prevented them from participating. The Minister of Health at the time convened a meeting with the Competition Commission and gave the assurance to stakeholders that they would not be found foul of the Competition Act, given that the department was convening this. Despite that, the cooperation from the sector was poor, and so we were unable to proceed. We then, given this lacuna in the system, and many players arguing thereafter that actually there's a need for a price list. Some of those same players that struck down the previous list. We then approached the Health Market Inquiry, or approached the Competition Commission that established the Health Market Inquiry, indicating that we have this problem and we think that it would be appropriate.
But what you started with is a reference pricing system. So can you explain what the relationship is between the reference pricing system and the coding system?
So the reference pricing system includes a coding system. So the reference pricing system will have a code. It will have a description of a code, which will include a procedure, and then it'll end up with a price for that particular procedure. So if you have a code but you don't have prices linked to it, it's a bit difficult to then deal with that. There are some challenges with the way the coding system has been used. So in our submission to the Health Market Inquiry, we provided evidence of a number of areas where there was what we call upcoding. Because in the Medical Schemes Act, the scheme has to pay in full for prescribed minimum benefits, and the obligation for those conditions that are not PMBs are different. And it was very clear that when providers were aware of what all the PMB codes were, they would prefer to bill on a PMB code rather than a non-PMB code. And the epidemiology of the country would suggest that the incidence of that particular condition is not as significant as the claims data would suggest.
So, and ICD-10 codes have a price attached to them.
Yes, in the reference price list. But my colleague deals with the ICD-10 codes, which the public sector uses as well. But it's obviously not for the purposes of pricing, but for the purpose of health information, planning, and monitoring, etc.
We heard evidence day before yesterday, I think, that there's a link between the ICD-10 codes and the reference price list coding. Would that be a correct submission?
You want to answer?
Yeah, yes, there is a relationship, but let me just clarify in terms of the ICD-10 code. The ICD-10 coding, it's mainly for coding of diagnosis. So in terms of the coding, it's an international statistical classification of disease, which is owned by the WHO. But in terms of implementation in the country, then the National Department of Health then coordinates that implementation, working with the various stakeholders, such as the Council for Medical Schemes, all the medical aid schemes, the medical aid administrators, and also in terms of then the implementation of the ICD-10 coding was then implemented in conjunction with the Council for Medical Schemes, which then regulated its implementation. And in terms of then the codes, you find that at the end of the consultation, then the doctor, once they've determined the diagnosis, they have to then put a code so that then the medical aid scheme can be able then to pay in accordance with the code for the diagnosis. So it's a very then important standard for coding for diagnosis.
A follow-up question, Mr. Ngcukaitobi. Just to understand this correctly, my understanding from what we've heard so far is that the procedural code in the reference price list is what is used to determine reimbursement, whereas the ICD-10 code is used to determine what the diagnosis is. But there's some mirroring between the two. So you might be able to match an ICD-10 code with a procedural code in the reference price list. But the main code that determines whether you're reimbursed as a doctor is the procedural code. Is my understanding correct?
Yes, your understanding is correct, but obviously the procedure that is undertaken has got a direct relationship to the diagnosis of the condition.
Can I maybe add, I, on a regular basis, get calls from practitioners asking me, what code should I use? My response is, I don't really know. I'm not sitting with you, so it's difficult for me to help you with that. So clearly there is a problem in the industry about how codes are determined. But very often the person that's asking me the question is not a clinical person. It's the administrative person who must submit a bill. And so he or she just wants to know what is the code that will get reimbursement, because we're having this problem and we thought that you may be able to give us the answer. I think so. It's a problem in terms of the way people understand and interpret it.
But I mean, isn't there something a lot deeper than this? Because you see, the problem with this coding is that if you're dealing with a Section 59 implementation regime, we don't know, because the medical schemes haven't given us the data, how much of those claims that fall under Section 59 are because of innocent coding errors, or they are as a consequence of deliberate fraudulent conduct. If the majority is innocent coding errors, the absence of a clear regulatory framework impacts on people's lives and practices being shut down, and unfair imputations of fraud against them. Now, when they say, well, when they phone you, the administrative assistant phones you, say, well, Dr. Pillay, what code should I use? And the answer is, I don't know. That cascades across the industry. No one knows what the code should be. And this is part of the concern of at least this panel, that the gap in the coding enables abuse.
We would agree with you that the issue of coding is a huge problem in the industry. I think the Health Market Inquiry as well, in their interim report, flagged this as a problem. We ourselves have, in our submission, flagged coding as a huge problem. Coding, however, must go hand in hand with a panel that would appropriately approve the codes, because it's also about the clinical skill to appropriately craft the codes. The coding is also the subject of a lot of commercial interests. And so we've had great challenges in trying to implement a coding system in the private sector because of those challenges.
You said that the reference price list is linked to the diagnosis code. What's the status of the reference price list as far as its relation to cost? You haven't been able to undertake a costing exercise. So how do you come up with that figure? And then how does that then play into what the medical schemes reimburse?
So at the time when the reference price list was utilized, or a document that was used by the industry formally, the process was a bottom-up costing, which included an understanding of what are the operating costs of a practice, the time that the clinician spent, et cetera, and that came together in a particular price that was used. After the reference price list regulations were struck down, we did not publish a price list after that. However, our understanding is that many medical schemes continue to use the price list with an inflator from what had historically been published as the basis for their calculations. But we have not published, since the regulations have been struck down, any price list.
Now, how would the price list and the costing reflect a difference between practitioners who have practices in Sandton, where the operating costs are higher, and those who have practices in Giyani?
Yes, so one of the things we often debated when we were doing the reference price list is, do you provide a single price or do you provide a price range? And we had opted to provide a range so that you can have a sense of what is the range, what would be the lowest possible price and what could be the highest possible price that could be charged. What's interesting, though, is that the contribution of many of those types of operating costs, such as rental, et cetera, are marginal relative to some of the other costs that may be attributed, such as labor. Labor costs are a significant contributor to the overall price for a particular procedure. And so understanding that it's important in coming up with the price. But our plan was, or we had indicated at the time of publication of the last reference price list, that provide a range so that people understand, or schemes understand, what would be that potential range.
Just tell me, I just want to come back to the example you make, that you usually get calls from administrative assistants. That is a good example because it provides precisely the basis of why people are complaining. So when they say, well, what code should I use? The schemes will say, well, you know what code it is because we've given you the code. Now, why are they still unable to know what code to use? Because the schemes say it's obvious what the code is.
Yes, a bit of a circular argument. So I would say to them, well, what's the problem? Why the scheme saying to you they wouldn't pay on that code? Well, they don't quite understand what the reason is, or they don't appreciate the reason. And they believe that somehow we know what code it is that the scheme can never refuse to pay, I suppose is what I'm saying. Because they said the practitioner is upset that he's not being paid, and can you just give me a code so we can get this account paid? And so that's I think the difficulty that practitioners have, and schemes on the other side, engagement with those practitioners about being very clear about how they actually intend paying accounts, because that's really the problem.
What codes are the schemes using? If the department doesn't know the codes, who knows these codes?
No, it's not that we don't know the codes. People do not know which code to use for that particular condition. So,
yes, but let's take that example as a narrow one. But if you yourself don't know, and the doctor doesn't know, and the scheme also doesn't know.
I don't think the scheme doesn't know. I think the schemes question is that the codes do not add up to the procedures that you're billing us for. And so that's where this, because the schemes have inbuilt systems that flag for them that this code doesn't match with what you're claiming for. So something's not right. And so, but they're not telling that to the practitioner to say, well, choose one of this, because it's either you have this patient has this condition or that condition. Or if they have both, then maybe you must fix the codes or whatever. But they don't counsel practitioners about how they should provide a proper submission, right? So they simply say this is rejected, and then that's
Why can't the same person who calls you call the scheme and get the scheme to answer that question?
That's exactly what I ask, and they say, well, the scheme basically tells us this code is wrong, they're not going to pay it, and it's not their job to help us get the right code. So we thought maybe you can help us.
Thank you. We can continue.
Chair, on the specific issue relating to the investigation, I suppose the only information I could share with you that may be useful is that prior to this investigation, myself and the department, who usually would deal with matters relating to medical schemes and policy, etc., had never received any complaints of the nature as it is presented now. I have received complaints that medical schemes refuse to pay suppliers, and there are always disputes between suppliers and schemes, as well as patients and schemes about what should be reimbursed and what is not being reimbursed. The matter as it's presented now, we've never received a formal complaint. The first time I understood this matter was a few months ago, when this matter was in the media, and the former Minister of Health convened a meeting where we understood from doctors that were affected about what actually happened, which I think raised the flag that maybe in our amendments to the Medical Schemes Act, we need to review the way various sections are structured to deal with this matter more effectively. And so we would be hoping to do that in the revision of the Medical Schemes Act.
Just tell me about the reference pricing. You say that because the regulations were struck down, I mean, that striking down happened more than 10 years ago. And what has been the actual problem with getting the system back on track?
Well, I suppose at the point when the regulations were struck down, the department was faced with two options. The one option was to redo the regulations, complying with the legal requirements of the matter being served before the National Health Council, and thereafter proceeding in a manner that would then put the reference price list up again. The alternative is to do something different, and the Minister of Health was of the view at the time that this reference price list is always going to be in dispute, because actually the issue was not whether we follow the procedure of the regulations and table them before the National Health Council. The reality was that practitioners saw what tariffs they were going to get, and they said they don't like it, that if these tariffs continue, then they will go to court and they would have them struck down. So the minister's view was that, well, look, if you're going to go back and do this, why do you think you'll get a different answer? Because all you're doing is having the same fight again. So should we not deal with this matter more decisively? And some of the problems that the reference price list process had would need to be fixed in order for us to do that. So one of the problems we had was that we had asked practitioners to provide us with the costing of their practices, so to provide information about the operating costs, labor costs, etc. We would then, with the defined methodology, then come up with a tariff or a price. And clearly, when we received the information about the costs, just based on our own information, it was clear that these were costs that are much higher than what we would have anticipated the market is. We then appointed an auditing company to go in and check as to why is it that these costs are so much higher than what we anticipated. And that company then found that these costs were inflated, largely because I suppose part of our fault is that we had structurally said that the various disciplines will appoint a consultant or an expert who would bring the cost together for that discipline. So surgeons would get a consultant who would collect the cost for different surgeons, put it together and submit it to us. And those individuals did not necessarily visit the facilities and basically saw getting as high a price for that particular group as their objective. And so when we did the verification or the audit, it became clear that the costs are much lower, and that's when the dispute started. And similarly, in the case of hospitals, we had some disputes about the methodology. And based on that, that's how the reference price list issue broke down. So the minister's view was that deal with this matter more decisively. We would need to have powers to go in and get this information ourselves. Historically, we've never been able to get this information from practitioners. They've been unwilling to supply information in a manner that would allow us to come up with what we would call a fair price. And so in order to do that, the view was that we need to have an inquiry that would get to the heart of the matters and make sure that the entire system is dealt with collectively, because there's also the issue about billing and what we call a fee-for-service model, which causes some of these problems as well.
Dr. Pillay, may I ask, we have received, there are certain allegations that have been made which suggest that the schemes flag practitioners on a number of bases, but one of the bases is that they are an outlier in relation to the price that they charge. So what I'm trying to understand is, what would the scheme legitimately have reference to in determining that this price that has been charged is not an outlier, but is not an appropriate price, bearing in mind what you're saying, that there is no reference price list or price in the market?
In fact, you might add to that question a much more simpler one. Who decides the tariff?
The tariff is decided by the practitioner, because practitioners on their own have the right to set their own tariff. The scheme has its tariff for what it's prepared to reimburse for that service. And so when a member of a scheme visits a practitioner, he or she is faced with the possibility that the scheme is not going to pay the full tariff. So many practitioners actually are not interested in whether you have a medical scheme or not. They're simply expecting to be paid in cash, and you claim from your medical scheme, and whatever the scheme pays you is what you're entitled to, and you can deal with all of the issues linked to that. So the practitioner has the right to come up with a tariff, yes.
Well, I suppose that's then where the question by Ms. Williams comes in. If a practitioner is entitled to decide their own tariff, what right does a scheme have to tell them that you are an outlier in relation to price?
Well, I'm not sure. I suppose schemes would be in the best position to answer that, but I would have thought that they would have to understand why it is that the tariff is so high from that practitioner. And that would be an inquiry to the practitioner, I would think.
Wouldn't the scheme just say, we will reimburse up to the level that we've determined, and the rest is balance billing, basically. So the member then bears the cost of the balance.
Yeah. So many, as I said, many practitioners would take your medical scheme information, but not bill, and ask you to pay up front, and then give you the procedures, and you claim from your scheme what you've paid, and the scheme may pay you less than that, and obviously the balance is then for your own account. Some practitioners would ask you if you have a medical scheme, and also ask you if you have got gap cover, and so they would make sure that they extract the balance from the gap cover.
The question is what interest does the scheme have in saying to a practitioner that you charge too much if they're not going to pay that amount in any event?
Yes, I'm not sure why they would do that. I've never engaged schemes to understand the detail about why would do that. I didn't understand that they were actually flagging practitioners that way. My understanding was, or the complaints that I've ever heard, was that they were of the view that practitioners were in the business of over-servicing patients, which is a different matter, as opposed to charging a tariff beyond what they would be willing to pay.
May I ask my question again? Because I still would be interested to hear your view on it as from the department. If a scheme flags a practice for having effectively charged a price that was too high over a number of years or claims, they flag that practice, and the intention is to claw back that money from the practice. What would they legitimately have reference to in determining what is too high?
I think a number of practitioners have understood. I don't know how they would have engaged the scheme on this, but accepted this is the tariff that the scheme would be willing to accept. And so in terms of that, there would be practitioners that would have achieved a full payment from schemes, and those would be the practitioners that would not have any queries linked to their tariffs. I'm not sure how they derive that currently, whether there's through the IPAs, et cetera, they have information about exactly what the scheme will actually pay for a particular service.
Is it possible that there's nothing?
Possible that there's nothing, yes. I'm not aware exactly, I'm just speculating what it could be.
Dr. Pillay, would the department be able to provide us with some statistical information regarding the number and distribution of private practitioners, and having that broken down by race and location and type of practice?
I don't have this information myself, but I could investigate whether we could provide that and to what level of detail. What I do know is that our information comes from two sources: the Health Professions Council, where the practitioners are registered with that council, and the second source would be the practice code numbering system. And depending on the level of detail about each practitioner, we would be able to provide that information in that context.
The department doesn't keep its own statistics?
No, it doesn't. We were only collecting the statistics of late in terms of our planning for the National Health Insurance. So we ordinarily never kept statistics of practitioners and where they were and that kind of thing. There is no licensing system for practitioners currently. It's only the only sector that has licensing in the private sector is private pharmacies.
Your practice code numbering system, does that make reference to race?
As far as I know, it doesn't.
Is that the BHF's PCNS?
That's right, yes. So the Council for Medical Schemes had contracted the BHF to perform that service on their behalf. So they have given us the information related to PCNS.
Thank you. If you are satisfied that you've told us everything you planned to, you can let us know. Otherwise, this will be the end of your presentation.
The only other matter I want to just clarify is, in terms of the submissions that you require from us, would we receive some communication about what exactly you would like us to, what information you'd like us to share with you, and so we can do that. Okay.
Thank you. That will be done. Thank you. That will be the end of the Department of Health's presentation. It remains of me to thank Dr. Pillay for the submissions that have been made. We will be in communication. I am slightly unsettled that correspondence was sent to your department, but it came to your attention only a day before you came. So that is something that your department needs to attend to, but we will make sure that it goes to the right person. We will take the oh no, there's no adjournment because there's no one else coming. So this will be the end of the proceedings for this week and for today. I think the next session is all right. The 20th of August. All right. Well, it will be announced publicly in due course. We are adjourned.